Hello and welcome to LiveLaw Daily, your quick, no-noise roundup of the biggest legal developments from across the country today. Today is 15th of July and the monsoons are hitting some parts of the country really hard. But the courts keep going and so do we. So, let's begin. For the first story today, can a student's mental health become a valid ground to transfer from one IIT to another? The Supreme Court had to consider exactly that question today. A bench of Justice B.V. Nagarathna and Justice R. Mahadevan was hearing the plea of an IIT Kharagpur architecture student who has sought a transfer to IIT Roorkee. Says he suffers from depression and requires specialized therapy that is unavailable in Kharagpur. According to his counsel, the treatment is currently available in Chandigarh and similar facilities are available at IIT Roorkee. It was also submitted that the therapy is long-term and may be required throughout his life. The student's counsel argued that the IIT rules themselves provide for transfers on medical grounds. But despite applying for migration in August 2025 along with detailed medical records, the mandatory medical board was never constituted. It was further submitted that 2 academic years had already passed while the request remained pending, even though the student was willing to attend additional classes to make up for any academic gap. Appearing for IIT, the institute expressed sympathy for the student's situation but argued that there were differences in the curriculum between IIT Kharagpur and IIT Roorkee and that allowing the transfer could set an undesirable precedent since the closing rank for admission to Roorkee was significantly higher. Justice Nagarathna, however, questioned that argument, observing he got a seat in IIT Kharagpur. The same merit must transfer, pointing out that the student had already secured admission to an IIT on merit and was seeking migration only on medical grounds. The Supreme Court has now directed the director of AIIMS New Delhi to constitute a medical board to assess the student and submit a report. It has also directed IIT Roorkee to keep 1 seat vacant until the matter is decided, with the next hearing scheduled for July 29th. And for the second story today, the Kerala High Court is examining a question that could have significant implications for access to life-saving cancer treatment in India. That is, if a cheaper alternative medicine exists, can it safely replace an expensive patented drug? Justice Harishankar V. Menon has sought expert opinions from the National Cancer Institute in Jhajjar, the Chittaranjan National Cancer Institute in Calcutta, the Regional Cancer Center in Thiruvananthapuram, and the Drugs Controller General of India on whether palbociclib, a drug that is no longer under patent and is manufactured in India, can be used as a substitute for the patented breast cancer drugs, ribociclib and others. The issue arose in a suo motu case concerning the exorbitant pricing of patented breast cancer medicines. Amicus curiae advocate Maitri Hegde told the court that ribociclib, manufactured by Novartis, cost around 58,000 rupees a month in 2022 and now costs nearly 75,000 rupees, making it unaffordable for most patients. She urged the central government to consider invoking provisions of the Patents Act, including compulsory licensing to improve access to the medicine. The drug manufacturers, however, argued that such a step was unnecessary because palbociclib is already available in India at a much lower cost and can be used for the same form of breast cancer. The amicus disputed this, submitting that the two medicines have different clinical and toxicity profiles and should not automatically be treated as interchangeable. Observing that this medical question lies at the heart of the dispute, the High Court said it first needed independent expert opinion before considering whether any intervention under the Patents Act was required. The matter will now be taken up on August 21st, by which time the expert institutions have been directed to submit their reports. For the third story today, should a person be barred from contesting local body elections simply because they have more than 2 children? The Supreme Court indicated that it's a question that may now deserve a fresh look. A bench of Justice P.S. Narasimha and Justice Alok Aradhe was hearing the case of Mangala Bhimrao, a former Sarpanch of Kakoda Gram Panchayat in Maharashtra, who was disqualified after the birth of her 3rd child under the Maharashtra Village Panchayat Act of 1959. The law, as amended in 2000, bars persons with more than 2 children from contesting panchayat elections. During the hearing, Justice Narasimha observed that the Supreme Court's 2003 judgment in Javed versus State of Haryana, which upheld a similar provision under the Haryana Panchayati Raj Act, may require reconsideration. He orally remarked that in a country like India, where the fertility rate is steadily declining, it is necessary to examine whether such laws continue to be justified and constitutionally valid. The case arises from proceedings initiated after a complaint was filed before the additional collector, leading to Mangala Bhimrao Rao's disqualification. Her appeal before the additional commissioner was unsuccessful, and the Bombay High Court later upheld the decision, observing that the birth certificate of the third child clearly mentioned the names of both parents and there was no material to discredit it. The Supreme Court had already stayed the High Court's judgment in November 2025. The matter will now continue before the High Court, with the broader constitutional validity of the two-child norm for local body elections coming under renewed scrutiny. For the fourth story today, Sonam Wangchuk's ongoing hunger strike has now reached the Delhi High Court, with the court being asked to intervene over concerns about his worsening health. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Tejas Karya issued notice on a public interest litigation seeking immediate medical intervention for Wangchuk and directed the union government and the Delhi government to respond by tomorrow. The petition was filed by Advocate Rakesh Kumar Saini, who appeared in person before the court. He submitted that it was an unfortunate situation where a social activist, while exercising his fundamental right to protest, was effectively risking his own life in public. The plea seeks directions to shift Wangchuk to a hospital and administer force feeding, including a liquid diet containing essential nutrients, vitamins, and minerals required to sustain him. The bench, however, deferred the hearing until tomorrow since no counsel for the union government was present. At the same time, it directed that its order be immediately communicated to the authorities and instructed that notice be served upon Additional Solicitor General as well as the standing counsel for the Delhi government. Sonam Wangchuk, who began his fast on June 28th, is now into the third week of his hunger strike. According to the petition, he has lost more than 8 kgs and his blood sugar levels have been steadily declining. For the fifth story today, does a wife's right to interim maintenance end the moment a divorce is passed? A division bench of Justice Vivek Chaudhary and Justice Renu Bhatnagar has held that a wife is entitled to continue receiving interim maintenance during the pendency of an appeal against a divorce decree under the Hindu Marriage Act of 1955, observing that an appeal is merely a continuation of the original matrimonial proceedings. The case involved an Indian Army officer whose employer had earlier been directed by the family court to deduct 30% of his gross salary after statutory deductions and pay it to his wife as interim maintenance during the divorce proceedings. That order had also been upheld by the High Court. After the family court dissolved the marriage in July 2025, the wife challenged the divorce decree before the High Court and sought continuation of the interim maintenance. The husband opposed the plea, arguing that Section 24 of the Hindu Marriage Act applies only while the original proceedings are pending before the family court, and that after the decree, the wife could only seek relief under Section 25, which deals with permanent alimony. Rejecting that contention, the High Court held that an appeal does not bring the matrimonial proceedings to an end. It observed that the same parties, the same cause of action, and the same dispute continue before the appellate court, and therefore proceedings under Section 24 also continue during the appeal. The bench further observed that forcing the wife to wait for the outcome of her application under Section 25 could leave her without any financial support during the appeal, the very situation that Section 24 was enacted to prevent. Accordingly, it directed the husband to continue paying interim maintenance at the existing rate until the appeal is decided or until further orders. And for the next story, the Delhi High Court is now examining whether former UPSC aspirants and coaching faculty should be allowed to act as scribes for candidates with disabilities appearing in the civil services examination. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Tejas Karya issued notice on a public interest litigation seeking directions to prevent such persons from acting as scribes. The court has sought responses from the UPSC, the Ministry of Personnel, Public Grievances and Pensions, and the Ministry of Social Justice and Empowerment. The petition has been filed by the Deep Stambh Foundation, which works with persons with disabilities and civil services aspirants. It seeks a direction requiring every scribe to furnish an undertaking stating that they never have appeared for the civil services examination and have never worked as a UPSC coach or teacher, with penalties for making false declarations. According to the petition, the current UPSC notification permits scribes to possess qualifications up to the minimum educational qualification prescribed for the examination. Since that qualification is a graduate degree, former UPSC aspirants and coaching faculty are also eligible to serve as scribes. The foundation argues that this has created a category of conflicted scribes, individuals with extensive knowledge of the UPSC syllabus, examination pattern, and answer writing techniques. It alleges that such scribes may go beyond merely transcribing answers and could influence the content or structure of responses, thereby compromising the fairness of the examination and public confidence in the civil services recruitment process. The High Court will now consider the matter after receiving responses from the authorities. For the seventh story today, the Madras High Court has drawn attention to an issue that rarely enters public discussion: the psychological impact on judges, lawyers, and investigators who are required to repeatedly examine sexually explicit evidence in criminal trials. A division bench of Justice Anand Venkatesh and Justice K.K. Ramakrishnan observed that the justice system cannot treat its people like computers, expecting them to repeatedly view graphic material without any institutional support. The court said that if the mental and neurological effects of such exposure are ignored, investigators, prosecutors, defense lawyers, and judges risk becoming burnt out, traumatized, and emotionally numb. The observations came while the court was hearing the appeal of Suji, also known as Kasi, who was convicted and sentenced to life imprisonment till the remainder of his natural life. According to the prosecution, a laptop recovered from him contained obscene photographs and videos of several women. During the investigation, the crime branch of CID had to sift through the material to identify evidence relevant to the complainant in the present case. The bench noted that the investigating officer had to examine nearly 60 files of hardcore explicit material to locate the evidence relevant to the case. It observed that the same disturbing material also had to be viewed by the prosecutors, by the defense counsel, and the judges hearing the matter. Contrasting this with the pre-digital era, the court observed that legal professionals earlier dealt with evidence primarily through documents, witness testimony, and medical reports, which created a degree of emotional distance. Today, however, they are often required to repeatedly watch graphic videos and images, exposing them to what the court described as vicarious trauma. Observing that the law has evolved to protect the integrity of digital evidence but not the people handling it, the bench called for mandatory psychological screening and regular counseling, along with decompression protocols, rotation of personnel, specialized training, and secure procedures to minimize unnecessary exposure. It said that these measures are not a luxury, but essential to preserving the integrity and sustainability of the justice system. And for the next story today, the Madhya Pradesh High Court has allowed a 52-year-old woman to undergo IVF treatment despite the Assisted Reproductive Technology Regulation Act of 2021, which prescribes an upper limit of 50 years. The case was heard by Justice Vishal Mishra, who was dealing with a plea filed by a couple after a hospital declined to process their IVF request, citing the statutory age restriction under the ART Act. Before the court, the couple explained that their only son, aged 21, had died due to organ failure following jaundice. They submitted that they had been left childless and because of their age were no longer able to conceive naturally. And as a result, they approached the High Court seeking permission to undergo assisted reproductive treatment. The court noted that the woman had been medically examined and found fit to undergo the procedure. Referring the earlier decisions by the Madhya Pradesh High Court, it observed that where doctors certify a patient to be medically fit and the couple voluntarily accepts all risks involved while waiving any future liability against the treating doctors, the age restriction need not operate as an absolute bar. Accordingly, the High Court permitted the couple to proceed with the IVF treatment, recording their consent to bear all consequences of the procedure and relieving the doctors of any future medical liability arising from the treatment. And finally today, the Aircraft Accident Investigation Bureau has told the Supreme Court that there is no need for a court-monitored investigation into the Air India AI-171 crash that claimed 260 lives in Ahmedabad on June 12th of 2025. In an affidavit filed before the court, the Aircraft Accident Investigation Bureau said its investigation is being conducted independently in accordance with Indian law and international aviation standards, and therefore there is no justification for replacing the statutory investigation with a judicial one or any other alternative mechanism. The Bureau emphasized that an aircraft accident investigation is a fact-finding and safety-oriented exercise. It told the court that its purpose is to identify the causes of the crash, contributing factors and systemic shortcomings so that similar accidents can be prevented in the future. It added that such an investigation is not meant to determine criminal liability, award compensation, or apportion regulatory blame. The affidavit also highlights the international nature of the investigation. Since the aircraft involved was a Boeing 787-8, the US National Transportation Safety Board is participating in the probe, along with Boeing, GE Aerospace, and the investigation teams from the United Kingdom and Canada, this being in accordance with the Chicago Convention and ICAO Annex 13. According to the Investigation Bureau, 49 of the 66 mandatory investigative steps prescribed under the international standards have already been completed. The investigation is currently in its analysis phase, with specialist teams examining operational, technical, maintenance, and human factors. The Bureau expects the remaining investigative work to be completed in about 6 weeks, after which a draft final report is expected to be ready around October 2026. And that brings us to an end to today's edition of LiveLaw Daily. You can find links to all the stories we covered in the description box below. For complete reports and continuing coverage, visit livelaw.in, and we'll be back tomorrow with everything that is law.